Today I'm going to take a look at the Hunter Biden plea deal. We're going to use this article from the New York Times. It was one that I thought would allow me to insert my opinion and analysis the best. That's why I chose this article. The column is titled, Is the Hunter Biden plea deal really a slap on the wrist? Not remotely. Now, I have to say, I disagree with that a little bit. I wouldn't call the deal a slap on the wrist. I also wouldn't say that it's a harsh deal or it's a rough deal. And I wouldn't use the words not remotely. I would fall somewhere in the middle. So we're going to read through this article. I'm going to provide my opinion and analysis. My name is Attorney Joe Pometto. I'm a practicing criminal defense attorney in the Pittsburgh region. This is my show, Joe the Lawyer. If you like my content, please like, subscribe, comment, and share. Those are all free ways to support the show. Also, sign up for my email list. Another free way to support the show. Get updates on my content on my law firm, and also receive a free PDF on what to do when pulled over by the police. Now, before we jump into this story and I give you my analysis on the Hunter Biden plea deal, everyone, raise your cup, your glass in the air. Today, I'm drinking hot coffee out of my thermos because as soon as I'm done with this video, I'll be running to court. Raise your cup, your glass in the air. Cheers with me. It tastes better when we sip together. Cheers. All right. Hunter Biden's tentative federal plea agreement is bound to displease partisans on both sides, which is one sign that it's a fair and suitable disposition of the long-standing investigation of the president's son. And I will agree with that to a certain extent. Usually the result of a good negotiation means both sides are displeased to a certain extent. Although I have to think that Democrats are not that displeased with this deal and Republicans are displeased with this deal. Although, I mean, some Democrats might think, oh, well, this was a witch hunt, etc. I think the facts show otherwise. The deal revealed in court papers Tuesday requires the younger Biden to plead guilty to 2 misdemeanors stemming from a failure to pay taxes owed for 2017 and 2018. The government also levels a felony charge that Biden lied about his drug use when he acquired a gun in 2018. Rather than require him to plead guilty to that crime, the government agrees to drop the charge if Biden keeps his nose clean for 2 years under a practice known as pretrial diversion. So I can do a lot of my analysis right here. We will run through the rest of the article, though. Number one, I'm a criminal defense attorney, and while I have handled white-collar crimes, I haven't done any tax crimes or tax avoidance crimes, which are generally litigated in a federal court. I do mostly state court practice, though I do some federal. So it's hard for me to say whether, the $100,000 or so, I believe, that he didn't pay in his taxes is worthy of 2 misdemeanors. That certainly could be the case. But I really can't say. It feels to me, based on a lot of criminal practice, that would be a standard offer or a standard deal. And the thing to understand is anybody who pleads to misdemeanors is generally not going to be convicted of jail time. In Pennsylvania, we have summary offenses, misdemeanors, and then you have felonies. And I believe the federal system is pretty similar to that. Misdemeanors are seen as less serious than felonies. The only time people go to jail on misdemeanors is if they have some sort of mandatory sentence or they're repeat offenders, right? They keep getting trouble over and over and over again. I don't believe that Hunter Biden has a prior record of criminal convictions. So I'm going to treat this as 2 fresh new misdemeanors on his record. Therefore, probation would be in line with that type of punishment for a first-time offender. Now, this other felony charge, is a charge of possessing a weapon while being a drug addict. We do not have a similar analog for that under Pennsylvania law. So that's an interesting sort of offense. I personally, that's sort of a bizarre law. I understand the thrust behind it, but I sort of think the law is silly. So let me just put that out there to start. A person, let's say a person's a longtime gun owner, hunter, firearms enthusiast, and they become addicted to drugs. Are they suddenly guilty of a crime because they have a gun collection? It just seems to me to be a pretty silly law. I don't know all the intricacies of it. Maybe it's something I can look into later. But let me just put that off the bat. Well, he pled guilty to that crime. He was obvious, if we read further, that he was, in fact, guilty of that crime. And the interesting thing is he's going into a pretrial diversion program. So that means that if he keeps his nose clean, does everything that the government asks him to do for those 2 years, he won't end up being convicted of this. Okay, it could be expunged or removed from his record somehow. However, again, that's not uncommon for first-time offenders, and I've put people with felony charges into similar programs. The one thing I would say is in Pennsylvania, I think a similar analog is when a person doesn't reveal prior criminal convictions on an application for a gun. That's actually a felony under the background search laws. And what we do in Western PA, or what law enforcement generally does in the district attorney's office, is they will reduce that to a misdemeanor, but it still generally results in a conviction. So this crime, my first thought is it's a silly crime. And then my second thought is, well, it's a felony and it's going into a pretrial program. While not that common, it can be done, but it's also sometimes handled as a misdemeanor. Honestly, it's such a close call. It's hard for me to say that there was any mistreatment here. This deal that I am seeing, I do believe, and I would say with confidence, that any other person, a middle-aged individual with no prior criminal record, probably receives something identical or very similar to what Hunter Biden received. So I wouldn't call this a slap on the wrist. I also wouldn't say that it's by no means a harsh punishment. So anybody trying to paint this as something atypical, I think, is incorrect. This appears to me to be a standard offer on these types of charges, a standard offer that any other citizen would get. And in that sense, he wasn't treated more leniently than anybody else, and he also was not treated more harshly than anybody else. Received a standard offer. And I can tell you, for the most part, what I see in practicing criminal defense is that that most district attorneys' offices, they don't want to be perceived. Most prosecutors and judges, they don't want to be perceived as giving favoritism out. They do not want that perception. So a lot of offers are very regimented, very standard. Now, that can change when there are factual issues in the case, like if the Commonwealth can't prove the case or some sort of extreme extenuating circumstances. But they're going to be very careful in a situation like this to not have that happen to Hunter Biden. So let's go through the rest of the article. Biden haters will assail the arrangement as a sweetheart deal, proving the Justice Department is in the take for President Biden. Hater-in-chief Donald Trump has already accused the corrupt Biden DOJ of giving Hunter Biden a traffic ticket. The LA Times is obviously showing their bias here. But it's still an interesting article. The charge is, of course, spurious. Not only President Biden, but also Attorney General Garland kept their hands off the case. Delaware U.S. Attorney David Weiss, a Trump holdover, was allowed to remain precisely so that he could finish the case, even though new administrations typically appoint their own top prosecutors. And I believe that was a good decision by the Biden administration in order to not have the appearance of Biden's new attorneys coming in and deciding not to prosecute Hunter Biden. That arrangement kept the case at arm's length from the administration, but could warrant an objection from Biden's defenders. As the late Justice Scalia once observed of special prosecutors, Weiss' presence exerted a nearly irresistible pull toward bringing some charge against Hunter Biden. So, what he says is anytime a special prosecutor is involved, generally charges will be brought. A dismissal of the case might have been plausible given an unremarkable defendant and a prosecutor appointed through the standard process, but it was basically off the table from the time Weiss was allowed to stay in office to oversee the case. I tend to disagree with that. I think that it was handled just like it would have been handled for anybody else. Cheers. Biden family supporters could also note, while charges in the proposed plea agreement are bona fide, they're not the crimes of the century. I agree with that. Hunter Biden reportedly paid more than $100,000 in taxes he failed to pay on time. Doesn't excuse the crime, but it does distinguish him from a typical tax defendant. As for the felony count, Biden apparently had the gun in question for less than 2 weeks before his then-girlfriend threw it away. More important, as UCLA law professor Adam Winkler's pointed out, the Justice Department rarely charges anyone for lying on gun applications, although that does happen very often in state court, especially not for false statements about drug use. When it does, the case nearly always involves a defendant who, unlike Biden, is suspected of using the weapon to commit a crime. Okay, so it looks to me like actually what he did, and sorry, I haven't done a ton of research on this. It looks to me like he lied on the gun application about drug use and bought the gun and had it for 2 weeks. So it wasn't the scenario that I stated. That is commonly prosecuted. In Western Pennsylvania, any false statement is prosecuted, especially when it's about let me say this, a material false statement. I mean, if somebody puts down the wrong information about their address, okay, that's just a written mistake. Most commonly what we see in Pennsylvania is the person will not reveal their prior convictions. And if they don't reveal their prior convictions, that's a felony charge that is oftentimes reduced to a misdemeanor. However, it's rarely given pretrial diversion programs in Allegheny County. Usually that results in a conviction and probation. So, I would defer to the common practice in this jurisdiction because common practices differ from jurisdiction to jurisdiction. Some counties are much harsher on gun crimes than other counties. Some counties it depends on the issues that region is dealing with. So you can't compare it necessarily to the treatment that he would get across the country. You have to look at what that particular office would normally do. The charge may be even more questionable under the federal court's recent Second Amendment jurisprudence. Last year, Supreme Court struck down a New York law required a special reason for carrying a gun. And this month, the Third Circuit of Appeals in Pennsylvania held that a Pennsylvania law prohibiting felons from possessing guns was unconstitutional if applied to people convicted of nonviolent crimes. That's a completely different law. So I just don't agree with this reasoning here. These are two very separate and distinct statutes, so I would disregard that. The bottom line is that both sides have plenty to gain or lose from the Hunter Biden case that may well have produced a sensible bargain. I agree with that. The proposed deal, which is subject to approval by a judge, would allow Biden to avoid going to jail and turn the page on a dark chapter in his life. It would enable Weiss and the department to obtain a conviction and avoid trying a case with dubious prospects before a jury. A prosecution of a defendant who committed tax crimes during a period of drug addiction and then turned his life around and paid the taxes would be very losable. I agree with that, but I think it would be very winnable. None of this will prevent Trump and his blah, blah, blah. I'm not going to talk about that. It's just partisan BS. So ultimately, I do think that the deal is probably pretty fair. I think it is something that somebody else in that jurisdiction would have probably received, substantially similar, a substantially similar offer, and it doesn't deviate very far from regular prosecutorial practices on crimes of such a nature. So while I don't believe it's a slap on the wrist. I mean, he's going to end up with convictions, probation. It's going to build on his prior record, a couple of years of supervision. I don't think it's a slap on the wrist. I think it's standard. It's also not harsh treatment. It's a good, fair deal. So kudos to the prosecutor involved in this case. If you like my content, please like, subscribe, comment, and share. My name is Attorney Joe Pometto. We cover legal topics. I give legal advice and talk about the legal world on this channel, Joe the Lawyer. If you like my content, please like, subscribe, comment, and share. And think about signing up for my email list. You can sign up in the description, in the link in the description below. Thank you.